同志們，我哋
Members, we have a quorum, and it is the appointed time for the Bills Committee meeting on the United Nations Anti-Terrorism Measures Amendment Bill 2017. This is our 5th meeting. Please invite the officials in. Today, the first item on the agenda is meeting with the administration. I'd like to remind you that last time we have started clause-by-clause examination of the bill. Here, I'd like to draw your attention to the fact that at the last meeting on the 28th of November 2017, some members asked questions for the administration to respond, and the administration's response is in CB bracket 2 557 stroke 17 to 18 bracket 02. Members, any questions on that paper? Mr. James Toll. 557 stroke 17 to 18 bracket 02. Sir, if you don't have a copy, please the clerk give him a copy. Mr. Toll, you can take a minute to read the paper, and I ask the official to walk us through the paper. Also, as before, we have officials from the Security Bureau, and I think we know them very well, so I won't introduce them one by one. Deputy Secretary, would you like to highlight any points in paper 557 bracket 02? Thank you, Chairman. The latest written response mentions a few points. Number one, at the last meeting, some members showed concern about Clause 6 of the bill with regard to new Section 11J, that a person should know the connection of his act to a specified purpose, and members were concerned whether it should be specified in the new Section 11K2 that a person should have the intention to leave the SAR for a foreign state for a specified purpose. We gave this very detailed consideration, Chairman. And we wish to point out that the present drafting is sufficiently clear to show that the Hong Kong PR must leave the Hong Kong SAR for a specified purpose before he would have been in contravention of 11K2. We believe, therefore, there is sufficient clarity, and we do not see the need to amend these sections. And also, at the last meeting, I remember it was Mr. Wu Chi-wai who asked that in Section 11K, if a Hong Kong PR has been trained for jihad or has provided training for jihad, and if it only applies to Hong Kong PRs, would it be too narrow? And he asked what factors we considered. In simple terms, now this is the 5th meeting. In fact, in the last 4 meetings and also in our 5 responses, we have touched upon this point. We don't have any new points to add. Mr. Wu Chi-wai asked whether Hong Kong PR with one-way permit can be deported if they break the law. We have looked at Cap 115, the Immigration Ordinance, and Section 20 bracket 1 in it. It says that a non-PR may be deported if it has been found guilty of an offense punishable with imprisonment for not less than 2 years, or the chief executive deems it to be conducive to the public good. So this non-PR can be deported. Chairman, this is our short response, please. Mr. James Toh would like to speak. Before I give the floor to Mr. Toh, I'd like to tell you about arrangements for this meeting, because at 4:30 another panel will hold a meeting here. So we will have to adjourn the meeting at about 4:30. Mr. James Toh, 5 minutes. Chairman. 11K. If you look at 1 and 2, In 1, there are the words with the intention, and that is to qualify for a specified purpose. In bracket 2, you do not have the words with the intention. Let me say this. I grant you that you need the intention for a specified purpose. Well, to reassure us, and because there is a difference here, can you find a way to add back the meaning with the intention, just to reassure us? I know we differ in views, but just to reassure us. And if you think that by adding something, still the meaning will not be distorted, because you have said that indeed you intend to have that meaning. DS. Actually, if the administration has given this detailed consideration and we think that the meaning is clear, we do think that there is no need to suggest any amendments. In terms of drafting, perhaps I can defer to the law draftsman to explain to you whether this is common and a general way of drafting, because I'm not the expert. Mr. Chairman, can I defer to our law draftsman? Which one? Is it Ms. Chen Carmen? Thank you, Chairman. I understand the concern of Mr. To, but as we said in the response, for us, for a specified purpose already shows that the person knows the connection of his act to the specified purpose and that the person has the intention of achieving the specified purpose. The convention for drafting is that if the wording already reflects the meaning fully, we will not add other words to repeat what is already said. Ever since Mr. To mentioned his concern last time, we prudently considered the point and we studied the issue together with the Bureau, and we believe the present drafting is sufficiently clear, and we believe there is no need to add more words to repeat the same thing. Well, Chairman, read it again. Look at it carefully. 1 is not just about specified purpose. A specified purpose is present in both 1 and 2, and I'm talking about the words with the intention too. You have the intention in 1 but not in 2. There is this difference. If you add the words with the intention at a certain place, and your meaning is not distorted, well, this is not absolutely necessary. Well, I think it is necessary, but you don't think so. But if you can add the words with the intention so you can shorten the distance between us. Because if in the end there is such a case that it is arguable to say that there is the intention in 1 but there is no intention in 2. Now, my understanding is that the DS has already studied the issue and they are unwilling. So, DS, any more supplement from you? Chairman, yes, please. Let me supplement. Whether it is the Chinese or the English, why do we have 11K1 and 2? 11K1, well, if you look at 11K, we are trying to catch those people who have the intention, who have a specified purpose, and they know that they are taking a trip for the specified purpose. We will not be wronging the innocent. Therefore, there are 1 and 2. In 1, it says that the PR has the intention to leave Hong Kong SAR for a specified purpose. Well, he leaves with the intention for a specified purpose. And also, at an earlier place, we say if he boards a certain conveyance, we can already catch him. And then 11K2, it is a very clear provision. saying that a Hong Kong PR must not leave the Hong Kong SAR or a place outside the SAR for a foreign state for a specified purpose, as long as he leaves Hong Kong for a specified purpose. And as long as he goes from a place outside the Hong Kong SAR to a foreign state, then he breaks the law. Therefore, there are two levels. Mr. James Toh seems to want to have the words with the intention to 2. If we add the words with the intention to 11K2, then before this person completes his trip, yes, we can catch him if he has the intention, but as drafted in 2, as long as he has done it, as long as he has left the Hong Kong SAR or a place outside the Hong Kong SAR, and if he goes to a foreign state for a specified purpose, now of course the purpose must be in his mind, and of course we have to look at the evidence, and as long as he does that, he already contravenes 11K2. The two are different. Let's just try to solve it like this, Mr. Chairman. After the meeting, if Mr. James Toh can propose certain wording to the administration, we can look at it again. Because now when we don't have any actual wording having been proposed, it's very difficult for us to consider this further. We believe 11K1 and 2 now sufficiently reflect the policy intention, but I will be very happy to hear from Mr. Toh if he can propose concrete wording. Mr. Toh, I think the DS proposal is quite appropriate. If after the meeting you can come up with certain proposed wording. I can do it now, Chairman. It's very easy. It's a matter of whether they want to do it or not. What she's saying is that if you add the words with the intention, because I like to use the English, and then she says it might be a distortion of the meaning. Okay, I can put this to the test. 11K2.
Outside the Hong Kong SAR for a foreign state for specified purpose. Okay. 如果佢加嗰個 with the intention 咧，就係
if they add the words with the intention, then it would read
foreign state with the intention for a specified purpose. 咁樣有冇扭曲你嘅原意啊？
Does it distort your meaning? Can you repeat, please? Are you talking about 11K2? Yes. After the word state, you can add the words with the intention and then for a specified purpose. DS, can you do that? Well, I can respond like this. You are saying he has the intention for a specified purpose. However, if he has already done something to achieve the specified purpose, then it will not be included in the construction with the intention for a specified purpose. I can seek legal advice about this. But the thing is, this person has not left Hong Kong. No. We say it like this. 11K seeks to catch people before these people leave Hong Kong. We want to nip it in the bud.
個大個黑色體係咩？就 prohibition on travel 啊嘛。
啱。咁但係
So it's in the bold characters is prohibition on travel. So now this is a Hong Kong permanent resident. There's extraterrestrial effect. Now, with reference to 11K2, now if this person is already in Canada and he goes to the US to engage in terrorist activities, now it's very difficult to nip this in the bud while he's in Hong Kong. Now, if he's a permanent resident and he goes from Canada to U.S. for jihad, and you are able to utilize subclause 2, perhaps we can let the legal advisor speak. Now, to use the example by the Deputy Secretary, now, if in now this clause, there's a comma there. So if there's a Hong Kong permanent resident, now he leaves any place outside of the HKSAR for a terrorist purpose, then he can be caught by 11K subsection 2, and it's not necessarily departing from Hong Kong. Now, if you add with intention for a specified purpose, why wouldn't that work? The policy, if you add the words with intention, then if you say that you cannot catch that person, then there is a difference in our understandings. Now, we thank the economic advisor for her comment. Now, our intention is that if there's a Hong Kong permanent resident and he is in a foreign country and he's proceeding to another place, another country, then either you don't know that he or she has done it, and if you know, then with this provision we can ask that foreign place where he was and tell them that this is against the law, and he intends with with Mr. To's wording, with the intention that this is against the law, so we notify the other place to catch this person, to arrest this person. Now, if there is the wording with the intention to, it's okay, because we have to prove the intention or purpose anyway. But maybe if we don't have the intelligence or evidence to indicate that he was going to do so, then the information only became available after he has done this act, and only then is the SAR government aware. And when this person comes back to Hong Kong, and if we arrest him at that point in the Hong Kong airport, then it's not with the intention to. He has already done that event, that action for that purpose. So when we drafted 11K2, we want to cover both possibilities. Now, whether we know or don't know that he has done this, then we must try to arrest that person. Now, if he has done it, then it's even easier to prove that person has the intention. Now, Mr. James To has proposed the wording with intention for a specified purpose. So I write that down, we will consider that, and we will provide a written and verbal response next time. Now, Mr. James To has submitted a version for amendment. Now, I don't think we will conclude the discussion today. Please let me speak. now he will come back, she will come back, and she will respond to you whether they accept your proposal. And if you don't accept that, you can still propose your CSA. Now, of course, if they don't respond according to reason, of course, anything can happen. And now, she did provide an answer, but you weren't satisfied with the answer. Now, with the intention, she will consider that, but I've pointed out that there's a difference with intention and without intention. Now, we come to clause-by-clause scrutiny. Please take out the blue bill, and that's page C2046. If you look at the marked up copy, it's 0003. Will it be Ms. Lee who will take us through? Ms. Lee? We come to clause 6 of the bill to propose adding section 8A. Now, a person except under the authority of a license granted by the Secretary cannot deal with property, and this is property specified in A, B, C, D, property in connection with terrorist activity, and then the 8A is wording is with reference to the existing legislation, and this has reference to now in the 2014 the UN felt that the existing wording did not deal with frozen property, and the wording was inadequate. So the prohibition of dealing with property, now that is already a practice in Australia, Canada, etc. Now the clauses, there are some other clauses that are related, so we can deal with those. First, the draft bill, clause 7, that is the marked up copy, page 7. Page 6 of the marked up copy. This is to propose the Anti-Terrorism Ordinance, clause 12, section 12, disclosure of knowledge or suspicion that property is terrorist property. It says that, sorry, now you are going by the number of the page. Now, disclosure, this is about the offense, so this is different. Now, since members don't want to jump to page 6, let's go back to page 3. Because it's more complex on page 6. Now, on page 3 of the marked up copy, I believe that the legal advisor wants to clarify something. Now, so please refer to the marked up copy. Now, the new 8, capital A, B, C, where it refers to terrorists or persons connected to terrorists, it has to be those terrorists in accordance with 4, 5, and 6 in Section 8. Now, those terrorists do not have to be specified in sections 4 or 5. So if one contravenes Section 8 or 8A, the penalties are the same. So can the government explain why is it that in Clause 8, now Section 8, the one only has to meet with the interpretations in Section 2, whereas in the other clause one has to be with reference to Sections 4 and 5. Now, we didn't amend Section 8, we added 8A. Now, Section 8 is about terrorists and persons linked to terrorists. That follows the definitions in Section 2. In Section 2, terrorists is those who intend to or did participate in terrorist activity, and persons linked to terrorist activities are those who are directly or indirectly linked to terrorist entities. Now, how to specify someone to be a terrorist as opposed to a person linked to a terrorist, that one has to refer to the mechanism in 4 and 5. So in 8A, we refer to Sections 4 and 5, and we say that is the terrorist property and persons linked to terrorist activity under Sections 4 or 5. Now, even though Section 8 has been in existence for quite a long time, it hasn't been made use of. So if one has to make use of Section 8, now there must be a specification of a person linked to terrorist activity. Now that has to be with reference to Sections 4 and 5. So Sections 4 and 5 are more direct and it's more clear, and it does specify terrorist and terrorist-related property. Now, let me supplement. Now, Sections 4 and 5, now, that is specified by the CE by gazetting, and so even though 8 and 8A both seem to be talking about handling property or collecting property, now one of them has to go through Sections 4 and 5 through the court, whereas in Section 8 one doesn't have to. As long as it meets the definition in Section 2, one contravenes the law. So now Section 8 is not a section that we are amending this time. It previously already exists in the ordinance. Now, when the Bills Committee drew up the ordinance and the amendment, now all along there was discussion of defining terrorists or persons linked to terrorists or terrorist-linked property, because there are a number of sanctions and there is a labeling effect with legal effect. So the government made clear in the Bills Committees that we would follow two avenues. Now, first, the UN Security Council does pass this, and it's notified to the entire world, and so we gazette it, and then as the legal advisor says in 8A, the CE can specify that. Now, also, this has never been made use of.
So this time around, when we seek to amend it, we'd like to reassure you and set things out clearly. 8A specifies this, and things are clear. We believe clarity in the law is important, and we want to reassure you. Mr. James Toh. Chairman, I don't know whether I have misunderstood anything. Section 8. When you responded to the legal advisor, you mean that even if it says or talks about terrorist or terrorist associate, still they have to be specified under sections 4 and 5 before you can invoke section 8. DS. 8A. No, I'm not talking about 8A, but 8. The original, section 8. Will follow sections 4 and 5 in order to operate 8. But when it comes to 4 and 5, we have to see what is a terrorist, what is a terrorist associate, and then the court will look at terrorist acts. No, please, do not duck the issue. In simple terms, you responded to the LA about number 8, and you say that in order to invoke section 8, well, there is no amendment this time around, but there must be specification under section 4 or 5 before you can invoke section 8. DS. Is that the legal understanding? DS. This is how I understand the law. Well, don't tell us that it is only your understanding. Is that the administration's understanding? Yes, it's the administration's understanding. Okay, then I understand. We have to set this out clearly. Number 2, since we are making amendments this time around, okay, let's say last time it was not clear enough. And if I ask you to act according to the present scope, because I don't want to see this contrast. Without 8A, your understanding may be okay. But now that you have 8A, and 8A mentioned specified under section 4 or 5, but this is absent in 8, then your understanding about 8 may not be that clear. If it is still within the scope, maybe the LA can comment. Why don't we add that back to 8 as a consequential amendment? DS. Can you add this back to 8 to specify under section 4 or 5? Is that a question for me or for the legal advisor? You can answer first. Mr. Toh. Now, section 8 is not something we want to amend this time. Because if you look at the long title, we may exceed the scope of the present exercise if we amend number 8. And also, secondly, if we were to do that, we have to go back and seek legal advice first. Can I ask our legal advisor to comment? Well, I'll say the same thing. Please speak up. Okay, I'll speak up. Well, I have to go back and take a look. As I see it now, the long title of the bill is to further implement a decision of the Security Council of the United Nations Resolution 2178. This is what it seeks to do. Can we also amend number 8? Or is it that they have certain thinking in mind to differentiate between 8 and 8A? In fact, this also applies to sections 9 and 10. Section 9 is about prohibiting the supply of weapons to terrorists and terrorist associates. You may not have it with you because you may not have it in the marked up copy. And in that section, only mentioning of terrorist is done. But then in section 10, it says if you recruit terrorists, then they again say as specified under section 4 or 5. But 9 and 10 are different because they carry different penalties. Therefore, I believe there is a purpose. But for 8 and 8A, since the penalties are the same, and it seems they are both talking about dealing with certain property, whether it is money or property. That is why I asked that question. Maybe the DS can explain, is it that you believe 8 and 8A are actually different in their purposes? DS? Or would you like to defer to the law draftsman? Can I invite our colleague from the international legal section to comment? Ms. Lee. Please speak into the microphone. Thank you, Chair. Let me try to add. When the ordinance was, or when the bill was drafted, as you can, or the ordinance, it is to implement Resolution 1373 of the United Nations. In Resolution 1373, it is said that each member state has to list certain act as an illegal act. And that is in para 1B of Resolution 1373. And that talks about terrorists and terrorist organizations. It doesn't mention any specification by any United Nations committees. Therefore, when we wrote Section 8, we would just say terrorist and terrorist organizations. And according to the requirements of the resolution, Section 8 seeks to specify illegal acts. And now we want to add 8A. This is to serve the purpose of freezing assets. And after Resolution 1373 was enacted, and there have been different UN conventions and international agreements, and there is now the requirement to freeze assets. And therefore, the FATF states that we should freeze assets of terrorists who have been proved to be terrorists. And in 2012, they say that our freezing mechanism is insufficient. In order to tackle the FATF's requirement, we do not intend to expand this to freeze the asset of possible terrorists. And that is why 8A says it must be specified under Section 4 of 5. This is to comply with the requirements of FATF, and we have no intention to expand the scope. Okay, that's clear. Mr. James Toh, they should go back and take a look. I won't force you to amend anything this time around, but it is very far from ideal. Many years ago, you enacted this ordinance. I don't know whether you have said what you just said before. If you have, it should be on the record, and that will be good. But if you're only telling me now, if it is still your understanding, then that's good enough. Even if you do not amend it this time around, in resuming second reading debate, you should include it in your speech that a member has identified this contrast, and so that people should not misunderstand that 8 is also amended as a result of amending 8A. Then can you do that, DS? Yes? We can go back and check previous BC records, and we can clarify the difference for drafting 8 and 8A, especially during second reading debate. We can also respond at the next meeting. It's best if you can amend it. If not, you should put down a marker instead of making things even more unclear by having 8A. Well, yes, this will also be minuted. Chairman, I'll stand in the queue. Well, you can have a go first. Okay, I'm really baffled by 8A. You use the words dealing with. If we talk about money laundering, it's a general term, but in fact we also use the words to deal with to describe money laundering. Okay. and you deal with terrorist property. Why is it that we never had this before? Is it that we were thinking of something? Because generally, we would say, for example, some illegal proceeds. There must have been an illegal activity, whether it's corruption or drug selling. There must have been an act. An act has taken place, and then there is the generation of illegal proceeds, and whether the person or a third party deals with those assets, then is an illegal act. How do we call this? Okay, we call now we're talking about terrorists and terrorist property. In other words, if a terrorist, I don't know about the situation, like he is convicted and he is imprisoned for 30 years, and he has some property. And, for example, for some reason, the administration decides not to forfeit the property, or maybe you can't forfeit it. But other people are dealing with the property. You know, the terrorists may not have these property as a result of terrorist acts. Is it your concept that terrorists may have property that are not linked to any law-breaking acts, like Osama bin Laden? He had some construction companies in Saudi Arabia. He was very rich before he planted bombs, and then he became a terrorist. Okay, he planted bombs and he should be imprisoned. But originally, he might have accumulated wealth by operating a construction company for decades. Why can't people deal with that property? Was it your concept that you could also prohibit this? Now, if he has the intention of using it for terrorist acts, say to buy weaponry, then it belongs to the same activity. But the property might have been the result of a few decades of hard work before someone becomes a terrorist. And say he needs to sell some property in order to pay for his own legal fees because he doesn't want any duty lawyer scheme lawyer. And if he is prohibited from dealing with the property, then he can't use it for legal fees. Okay, next. And suddenly, you write this clause. Now, how can we deal with this? Osama bin Laden may have accumulated wealth for decades. Well, if he bombs someplace, his property will be frozen at once. Well, I'm not answering on behalf of the administration, but DS. Chairman, Mr. To has asked a question in a rather extended manner. I can clarify certain points. Presently, in the ordinance, there is already Section 6 for the freezing of property. It states there that if the Secretary for Security has a reasonable suspicion that anyone holds property which is a terrorist property, he can issue a written notice. Unless he gives special permission, no one should deal with the property. And under this concept of dealing with property, well, this is not a new concept because under Section 6 bracket 12, there is a definition of dealing with. It is a legal definition. And I clarify, we are not changing the definition of the words deal with. But our bill targets one thing. And as explained by the DOJ colleague, if you rely on the Secretary for Security to have reasonable suspicion that someone holds property which is terrorist property and he has to issue a written notice before you can freeze the property, and you also have to specify a certain property because a terrorist may have 100,000 properties and you have to specify one property.
嗰啲財產呢已經可能俾嗰
The other properties may already have been deployed by the terrorists to subsidize other terrorist activity. So we have to act quickly. That means once the terrorist is specified under Section 4 or 5, then all his properties cannot be dealt with. And we follow the existing definition for dealing with. Now, whether the previous property is obtained from crime or obtained legally so that it appears legal, as long as the property is the property of a specified terrorist under the bill or is directly or indirectly owned or partly owned by the terrorist, for instance, owned jointly with his wife, or if it's property controlled by a terrorist associate, that property cannot be dealt with. And that is specified, made clear in 8A, that is in accordance with FATF's instruction for all member states to follow this practice, that is to build a global anti-terrorist financing network, and also in fighting anti-terrorism, in blocking the terrorist financing, that is a very important function, because terrorists need money to engage in terrorist activities. So funds or financing is important. So we agree that we must be comprehensive in circumspect in what we cover. So irrespective of whether the property was or planned to be engaged for use for terrorist activity, as long as it is a terrorist property, then it would be caught. Now, confiscation has a higher threshold. Now, perhaps I can ask the legal advisor to comment. Chairman, definition for dealing with. The issue is whether the dealing with is different under the new bill. So what is the question? There are two scenarios I think that have to be dealt with. I don't know whether it's been discussed in UN, but I have to ask this because it's now local legislation. Now, the terrorists might have done a lot of bad things, and the wife doesn't know about it, and they own a flat that was owned 50 years ago, bought 50 years ago, and the wife has paid for the mortgage, and it's still being paid for, and it's a jointly owned property. And if the wife doesn't know, and perhaps even doesn't agree with terrorist activities, now will the wife's half of the property be frozen forever or even confiscated? Then would it be unfair for the wife? Now, or you allow them to sell half the property, and if you don't allow it, you raise judicial review. Now, also if a terrorist has been in jail for some years, and during this time, for 3 years, and 3 years later, he left jail, and the property has not been confiscated, and he said that he has reformed himself. Now, will the property be in that state forever? Now, if that person has been released from jail, and you can say that he was still thinking terrorist while he was in jail, so you use the mechanism in sections 4 and 5. Now, say maybe that person is already suffering from Alzheimer's disease, and he's an old person's home. He is paralyzed and can do nothing, but he needs money to improve his health, and the property is still there. Now, can someone sell the property for that purpose? Can we make use of this license, or do we just punish him for the rest of his life? Now, in 8A, now in 1B, it says clear that it makes clear that if the property is directly or indirectly owned or jointly owned, then it still would be caught. So the half owned by the wife could be affected under 1B. On the second question, now, how long would the effect last? Now, according to 8B, it would be frozen as long as the person is a specified terrorist. And when he's no longer a specified terrorist, then the property would be defrozen. And okay, someone was affected but who is innocent. Now, when this ordinance was being drawn up years ago, this item was already fully discussed. So there was a special situation allowed for. That is, if the Secretary for Security, having considered all the circumstances, and if there is a benevolent third party, now suppose that person is doing a regular job, which is not a terrorist activity, but the salary is paid by the agent who manages that property. Now, would his salary be affected? Now, we don't intend to change the situation in the existing legislation. That if there's someone who relies on this for livelihood or relies on it for legal expense, and if it's reasonable, then one can get a special permission from the Secretary for Security so that the property, that the income derived from the money derived from the property would not be affected. Now, just now, Ms. Lee introduced 8A, and she asked the chairman if she could also cover Section 9. It is because 8A would be added to clause Section 15. That is, those who are innocent under 8A can avail themselves of the special permission under Section 15. Now, would that be used? Now, if you look at Section 15, now under 1B, it says very clearly, now if it's a reasonable living expense or legal expense, or if it's an expense under employment ordinance, it would be allowed. Now, that's Section 15, but How come there's the word license here? For instance, a real estate agent tries to sell the property. Does that mean that a license have to be obtained for that? Has to be obtained for that? Now, let's not try to imagine all the scenarios. Now, the important point is the license by the Secretary of Security. Now, certain factors must be considered, whether that's a benevolent third party who is not a third party, who is not a terrorist, and that person is a employee and it's a reasonable living expense, or it's an expense that he's entitled to under the employment ordinance. Now, the important point is whether the reason for dealing with the property is a reasonable one. Now, if dealing with the property is for the purpose of paying the salary of a regular employee, then that's lawful and reasonable. Then under a license by the Secretary of Security, this would be allowed, and this would not be caught under 8A as dealing with terrorist property. Now, on a benevolent third party, now, of course, that's true for an employee, but those who assist them in a lawsuit, yes, that's a reasonable legal expense. How about medical expense? That would be under 15B1, reasonable living expense. Now, is that understanding correct, Deputy Secretary? Now, if the medical expense is to benefit the benevolent third party, and the Secretary for Security feels that is reasonable, then that can be covered under Section 15. Now, I mean the medical expenses of the terrorists. Now, the legislation has not yet been made use of. Now, I'm talking about legal understanding. Now, it's my colleague has reminded me, under Part 6, Section 15, 1B, Roman numeral 1, there is the so-called reasonable living expense. That's the one referred to by the chairman just now. You are now talking about third party. Now, I'm saying that the terrorist is being treated by a private doctor, say. Now, 1B, it covers this. Now, these are exceptional circumstances. These circumstances can relate to, but are not limited to, anyone holding that property. So, if the person holding that property is a terrorist, then it wouldn't be limited to him. It would be related to him. That would be someone apart from him, or someone who holds the property, and we're talking about the reasonable living expense. So it can be quite wide. Now, so it would seem that it's covered. So it would be the reasonable living expense. Now, you now amend it. You're now saying that it can be applied also to the terrorist himself. Okay, let that be recorded. Also, I'd like to ask the legal advisor. I'll ask the administration. If there's no 8A under the existing ordinance, there is no clause dealing with terrorist property. Now, why is it that there is no clause dealing with the dealing of terrorist property? I'll ask Ms. Lee. Perhaps the Deputy Secretary can explain. I will ask Ms. Lee to explain.
Mr. Cho, in Section 6, there is already a provision to freeze property. But when the ordinance was enacted, we set out some conditions that must be met, including that the freezing must be in writing and directed by the Secretary for Security, and it has to be a specified property. And it was proposed that if there is terrorist property but the administration doesn't know about it, then it seems that might not have been covered by the present mechanism. That is why we are proposing 8A. So even if the administration doesn't know about the property at the moment, if anyone helps terrorists to deal with their property, then 8A will be able to cover that. No. 8A 1 ABC. It is specified property. You say could be specified, but you draft it to say knowing that it is specified. So it won't achieve the purpose you stated. You need to gazette it, or you must apply for a court order before 8A can apply. There is a timing difference. Well, she said that 8A would be able to cover certain issues, but it's not going to do it. You need to go through a court procedure, or first you have to have specification. Yes, specification will remain, but Mr. Cho, you mentioned Osama bin Laden. He is a specified terrorist. We would know he has an account in a bank, and the Secretary for Security can freeze it under Section 6. But perhaps he has another account in another bank, which is unknown to the administration at that moment, and we have not issued a notice. And under the present mechanism, we cannot prohibit the dealing with property in that account. But when we have 8A, no matter in which bank Osama bin Laden has an account, no one can deal with the property in all those accounts. Okay? Now I understand. Okay, let's go to page 4 of the marked up copy. Page 4. After part 3B, we add in part 3C. There are a few provisions here. 11J, 11K, 11L, and 11M. Let me talk about 11J. It interprets specified purpose in part 3C so as to allow 11K, 11L, and 11M to be understood with more ease. I think the committee has discussed this at length. And then 11K, prohibition on traveling for specified purpose. 11L, prohibition on providing or collecting property to finance travel for specified purpose. The drafting of 11L is a result of making reference to Section 7. And then 11J, or 11M actually, prohibition on organizing or facilitating travel for specified purpose. That is more or less it. Mr. Felix Chung. 11K. Let me talk about 11K. Is that here? You leave the Hong Kong SAR or a place outside the Hong Kong SAR, and you quoted the example of going from Canada to the U.S., you may discover that a terrorist is a Hong Kong permanent resident and he goes from Canada to the U.S. The Hong Kong SARG knows that he is in Canada, and you may inform the Canadian government not to allow him to travel to the U.S., right? But there may be another situation. If the SARG doesn't have any diplomatic ties or extradition agreements with a country, how can you prevent that Hong Kong PR from leaving that place? DS. Chairman, in the situation described by the member, well, we can use mutual legal assistance in order to inform the police and anti-terrorist authorities where the Hong Kong PR is, for them to watch and monitor this person, and if there is evidence that this person breaks the laws, the person can be arrested. But if we do not have enough information or evidence to do this, then when this person returns to Hong Kong, since we already have this provision, we can arrest him at the port or the airport, and then we can prosecute him with this provision. So there is a way, but it is just the timing. Well, you are saying he will come back, but what if he doesn't come back? Then there is nothing you can do. If the person is in another country, then it depends what evidence and information the enforcement agencies have. In Hong Kong, we have the criminal justice cooperation mechanism. The SARG has signed an agreement with almost 40 countries. And under these agreements, we can require other countries to provide assistance by collecting evidence and help us detain the person. But of course, we are still negotiating with some countries, but still we can cooperate with them. Perhaps Ms. Lee can explain. We can make use of mutual legal assistance in order to cooperate with these countries. Chairman, can I defer to Ms. Lee to say something? Ms. Lee? Thank you, Chairman. Mr. Chung, well, I can imagine if someone doesn't come back. In fact, this is also a requirement under UN Resolution 2178. And theoretically, that government, according to this resolution, has the responsibility to arrest these people and penalize them. As the DS said, it depends what information we can give to the other country in order to invoke international cooperation. We may need to give them the intelligence we have. And as the DS said, this person may eventually come back to Hong Kong, and we can make use of the criminal matters mutual assistance ordinance in order to ask the other country to help us collect evidence. It depends on the laws of the other country to see whether they can deal with our request. If there is not a bilateral agreement or an international convention, we will give them a promise of mutual benefit. In other words, if they should have the same requirement in future, we will help them. Right now, we do have quite good cooperation. But we haven't invoked Cap 252 to make a request, but we have cooperated with other countries on other criminal matters. Members, page 0004, 11J, 11K. Any more questions? Mr. To. Chairman, if I may contrast 8 and 11L, I'm thinking what 8 cannot cover, because to me 11L is quite superfluous. 8 says, well, let's go to 11L first. You finance the travel between states. So this person can go from one country to another and you finance the travel. But in 8, you can't provide anything. In other words, I remember I asked this question at a previous bills committee. Say if a humanistic organization offers food to a terrorist who holds a gun but who is hungry, who is famished, and you may give him some clothing. Well, I don't know whether clothing is property. And then you can give him 2 bowls of porridge. Is porridge property? Or you give him $1 and tell him to, or you give him $5 to go to 7-Eleven to buy a piece of cake. It is not possible theoretically, right? It's very strict. Not to mention financing the travel. So we can tell the UN that 8 is all-encompassing. It's very strict. It doesn't allow anything. Then why do we need another provision for travel? It sounds very strange. To me, 11L is unnecessary. DS. We think that 11L is necessary because 11K, 11L, and 11M are in one package. 11M is the actual traveling, but 11L is financing the travel or collecting property to finance travel. If want to nip such travel in the bud, well, if he doesn't have money, he can't travel. This is important. No, I mean, why 8 cannot cover this? 8 can cover everything. Look at it again. Make any property available for his benefit, including buying food, buying clothing, traveling. Chairman. 8 targets mainly a situation where you don't know or you are reckless as to whether the person is a terrorist or terrorist associate, and you provide financial services and other property. And you must have the intention to know or that you are being reckless as to whether the person is a terrorist or terrorist associate. When we designed 11L, actually, we considered that we have to implement the decision of Resolution 2178, where it states clearly that there must be express provisions to prohibit the providing or collecting property to finance travel. In Resolution 2178, it says we must focus on travel. That is why we have 11L. No, I mean, you can't give him money for anything, not even to buy food. As long as he is a terrorist, you can't give him any money. No, the DS is saying that this is a requirement of the resolution of the UN. Well, yes, and then we can tell the UN that we already have it because it is covered. Please wait. Please give them a moment. Can I defer to Ms. Lee to say something? Mr. Toh, 8 targets terrorists and terrorist associates. And here in 11L, we are targeting people who take the travel for specified purpose. They may go for a jihad, and indeed, part of it may duplicate Section 8. However, there are other people who may go to a foreign country to receive training And that travel may not be for the purpose of terrorist activities, but they go there for training.
And then they have in mind to engage in terrorist activities later. So this is not caught under Section 8. But if we have 11L and we know that this person is going to leave Hong Kong for some place to receive terrorist training, and then the terrorist and the travel financing for the travel would be caught by the 11L. Mr. To? So someone is not yet a terrorist, but is preparing to be a terrorist. Is that what you're trying to refer to? Now, the existing Section 2 explains what is a terrorist. How about terrorist associate? Associate should be much wider in Section 8. Terrorist association is also defined in Section 2. That is, so those who engage in training would be caught. Now, if they go to get the training, receive the training, they may not yet be controlled by terrorists. So the target includes those who are becoming radical in their thinking. So those who are not yet controlled but who are going to be controlled. Okay, I understand. So we move to 0006 of the marked up copy. Now, Section 7, Clause 7, this is to amend regarding disclosure of knowledge or suspicion that property is terrorist property. Now, Section 12 says that there are certain conditions where such property will not be considered terrorist property. Now, we move part of 2 to 2B and we add 2A. So if we say that if a person has made disclosure referred to in subsection 1 does in any act in contravention of section 8A, 1B or C, then the person does not commit an offense under section 14, 1A. Now I'm asking about bracket 2. You say whether the travel is contemplated or actual, whether that travel is undertaken by the person. Now, but previously under subclause 1, you say knowing that the travel would be for a specified purpose. So what is the question? That is, under 2, there was a failure before he departed, but even though he was just thinking about it, he would be caught. Now, Ms. Lee, our policy intent is to catch someone who has a criminal intent. Now, if he has the criminal intent to engage in terrorist activity, then if he purchased the airline ticket and booked the hotel, and but he couldn't actually go there due to a natural disaster, then he would still be caught. So we don't care whether he eventually got there. So this is the way it's worded in legislation abroad. This seems a reasonable provision. So let's go back to 0006. Ms. Lee has already explained this. Now, on adding 2A and 2B, any question? Wait a minute, please, Chairman. Now, what has been added? I'd like to ask the legal advisor. Perhaps Ms. Lee can explain further. Because you deleted the 2A, B, 2A and B. Now, the conditions in 2A are now under 2AB, under now 2B, and we added 2A, so that if the conditions under specified 2B, A or B are satisfied, then so this means that if there's disclosure, then he wouldn't be considered as having committed the crime. Now, this is a common design, fairly common design. Now, if we are going to strike a blow at terrorist activity, especially terrorist financing. Now, terrorists terrorists normally make the financing covered. So we want to impose a duty to disclose so that the law enforcement agencies can investigate and block the funds. So if a person has made suitable disclosure under the law, his legal liability would be waived. Now, is this the same in all cases? Perhaps the international division, our international division, can explain now, compared with other legislation. Now, as I understand it, the OSCO legislation has similar exemption. The purpose, as the Deputy Secretary said, is to encourage people to provide the information. So it's the clause is in money laundering legislation and it's also in OSCO. And now I'm talking about technical analysis. On money laundering, if you know someone or you suspect money laundering, you have to report it. Now, in this case, the reporting has been done to the Joint Information Center, and now the conditions under 2A money laundering, is that the same? Now, I don't have the legislation on hand on the legislation on money laundering, but it's already in Section 12 on of the Anti-Terrorism Ordinance. Now, it's basically the same as the legislation on organized crime in Section 25A therein, but in OSCO it's indictable crime and so on. Now in under OSCO it's about income from drug trafficking. Now, so one would be subject to penalty if one doesn't report it. If one knows it and doesn't report it. So that's the same in all the cases. Now the 2A, that's in accordance with the UN resolution. That's specified in the long title. That's Resolution 1373 of 2001. At that time, they don't allow the 2A case to be exempted. So you think 2A, the new 2A is redundant? No. Is it that they suddenly think 2A is appropriate for adding in and there was no such thought beforehand? There was the intention beforehand too. So it's in 12 bracket 2 of the existing 575. And why to add 2A? Because we added the new 8A. Now, because so we want 8A, 1B or C to be covered. So we added 2A. Now let's look at marked up copy, page 6. On the left side, the crossed out some wording. What's crossed out is now the 2B. I know that. I don't. So why is it not section 7 or 8? Now it's just the numbering that's different. Now 2A and 2B are separate. So previously there was the wording, and now it's 7 or 8 or 8A. Now 7 or 8, section 7 or 8, the crime involved. Now, so it's 14. Now 2A is about section. It's about the offense under section 14(1)(a). Sorry, I understand now. So we come to page 8 of the marked up copy, clause 14, section 14, offenses. This is to amend Cap 575, offenses, section 14. We need to add bracket 1 capital A and bracket 4 capital A to introduce the offenses. This is because you added 8A and 11K, 11L and 11M. This is a consequential amendment. Are the penalties the same or have they been increased? Now the penalties are the same as under section 7, 8 or 8 or M. So these correspond to their counterparts in Cap 575. Mr. Chung Kwok Pan, why is it that what is the level 6 fine. That I believe that's 100,000. Now, 1AB, it says level 6, but not in small letter A. Now, 1A, small letter A, it says fine, but it doesn't say what level of fine. Why doesn't 1AA not specify the level of fine? And also 4A, small letter A.
There is no cap, that is why. This is what we generally do. There is no cap. Does it mean all the property can be forfeited? Is that right, no matter how much it is? Ms. Chan, it depends on the court's ruling. But I can only say that the law doesn't state a ceiling. We can ask the legal advisor to tell us what happens with other laws. Chairman, can I please supplement for the information of Mr. Chong? We are adding in new offenses. That is why there is the new penalty. This is for Section 14. If you look at the writing of Section 14, anything that is done on conviction on indictment, it only relates to a fine. And even in the present ordinance, it doesn't say how much. Therefore, our proposed drafting is in line with the present ordinance. It depends on the case and also the court's ruling. Mr. James Toh, I don't exactly remember. Let me try to remember. Is it that in our laws we don't usually put a ceiling for fines? Well, I can see a difference here. If it is on conviction on indictment, it is to a fine, and then B, on summary conviction to a fine. I think the two are different. Well, of course I know the two are different. I'm talking about A, that the fine is not capped. I will now ask our legal advisor to explain to you. Yes, Chairman. This is not something invented by this blue bill. As the administration said, Cap 575 has been worded that way. And if there is conviction on indictment, well, for indictable offense, meaning that it is a more serious situation, then there can be a fine. And then if there is an amount or a particular number that will set the ceiling, and the judge cannot deviate from it. If it says 14 years, then the judge cannot say 20 years or 25 years. And secondly, if it is on summary conviction, which is quicker, it will be a fine at level 6. Now in Hong Kong, I don't remember the cap number. It lets you know the different levels of fines. And there may be a situation where if the fine has to be changed, then you just need to change that particular ordinance where the levels of fines are defined, and all other laws can follow. Say level 6, it is now 100,000. It can be changed to 120,000. So you just need to amend one ordinance. That is for easier drafting. And this kind of expression is not unique to this law, as there are other laws who also use the words to a fine or to a fine at level 6. Mr. Toh, I'm following up of Mr. Chong's question. When you say to a fine, it means it's infinite. Is that right? But my understanding is the law will not say infinite fine, but actually it is infinite. Well, there is no ceiling stated in the law. The fine can be $100 billion, right? I dare not say, why not? When you say level 6 is the maximum. But when you say to a fine, it can be 100 million, even $100 billion, right? So it means infinite. Why do you want to argue with me? But Chairman, my question is, I can see that with imprisonment, it is clear that it is 14 years and the other is 2 years. And in 4A is 7 years. Someone works for a terrorist and the other one is, how can I say it? You arrange for somebody to be trained to be a terrorist and the imprisonment is 7 years. My question is, let me give you an example. If the fine is infinite, you can say it is only reserved for really heinous crimes. Say, if there is an offense that entails life imprisonment, then I understand. When the imprisonment is for life, then the fine can be infinite. That I can understand. But if you cap imprisonment at 14 years, it means it is different from 7 years. And I can give you the example. Now, I don't know how Cap 575 is constructed, but and you are not talking about forfeiture here. But this one is a penalty. Say if imprisonment is for 14 years, you should also try to provide a ceiling for the fine. You shouldn't suggest that it is infinite. Drug trafficking, for example, is a heinous crime. You can still set it at 5 million or 20 million. And maybe 20 million for 14 years and for 7 years, 10 million. Then at least there can be a contrast. Even the fines can be contrasted. Would that be a better way to draft it? DS. Chairman, I understand where Mr. To comes from, but very often when we drafted these provisions, we made reference to the resolutions of the UN, which we need to implement. And information at hand shows that we have made reference to the 2012 sanctions against Afghanistan regulation of the UN. And it talks about prohibiting providing advice or training to some people. And it also says a fine, but it is not capped, plus imprisonment for 7 years. But if it is summary conviction, it talks about a fine at level 6 and imprisonment for 6 months. I can preempt your reaction. You can say it doesn't matter what happened in the past, but now, do you want to make it more orderly? Now, we can't really forgo the past because Section 14 is here. And as I was explaining to Mr. Chung, we are talking about flouting Sections 7, 8, and 9. What is 7? 7 is prohibiting the financing of terrorist act, and Section 8 prohibiting financing terrorists, and Section 9 prohibiting the supply of weapons to terrorists. The penalties are the same. On indictment, to a fine, and to imprisonment for 14 years. If we accept Mr. To's view and define the fine and put down a ceiling, then perhaps I will also impact on sections 7, 8, and 9. And also, in 14, there are many different things. 14 bracket 2A, again, it says a fine. And then 14.4, it says a person who contravenes section 10.1 or 11.1 or 2. Again, it is a fine. Now, if I define everything, then the scope would exceed way beyond the purpose of this bill. Mr. Felix Chung, Mr. To, have you finished? No, one last question. Well, you can see this coming. I never thought about the question mentioned by Mr. Chung. And then, now that I think about it, it should not be infinite for 7 years or 14 years. There should be a contrast. But it doesn't matter. I'll cut a long story short. I am making a general point. 14.1, 14.2, 14.4. I have learned from the experience of today, and I think this is not right. Say tomorrow, if there is a new law which is drafted like this, I will not agree. And what I can say is that this is your way to draft penalties. If it is 7 years and 14 years and yet the fine is also infinite, there must be a problem because you cannot reflect the difference. Say, for example, perhaps when imprisonment is 7 years, it must not be a fine at level 6 only. So what I can say is only that first, I will ask you to think about this. And if you come back to say you definitely would not amend it, I may consider moving a CSA. Of course, there may be an impact, but there shouldn't be an impact if I change it to 20 million and 10 million. I wouldn't make any impact on infinite fines. But at least I like to debate this to see whether this way of drafting fines, when it applies to crimes of different seriousness, whether this should be given more details. Well, you can say definitely you're not going to change, then I can write my own CSA. That's it. I don't want to dwell on this further. I'm sure the administration stance is also very clear. We are of the view that there may be too much impact. Well, you can answer me like this. You can say you won't do this time around, but you are willing to take up this point with the DOJ. That is for future drafting of penalties. And you can say after a certain time, you can respond to the AJLS panel. That can be an answer. I can wait for you. Okay? I give you some time. Then I may not want to move a CSA. Since you know my point, well, actually, I thank Mr. Toh for raising this point, but I must also point out that this is not just about drafting. Rather, we have asked the prosecution section or division about the penalties, and they gave us a lot of valuable advice. Well, then you can give me a detailed reply. Maybe you can convince me that you are right. Okay, I will ask the prosecution division again. Mr. Felix Chung, I'd like to ask, do you have sentences that have been meted out according to these provisions? Say B, fine at level 6 and imprisonment for 2 years. And can you show me cases where the imprisonment is 14 years, how much the fine was? Because I think the judge must act according to certain guidelines when he imposes a fine. The judge cannot just lightly say 500,000 or 10 million or 20 million. Do you have case examples? Chairman, Mr. Chung, with regard to this cap 575, touch wood, we have never invoked the ordinance. We have not prosecuted any offenses under this ordinance. And what about other ordinances? I can't say for the other ordinances. I can go back and do a study and I can ask the DOJ. But this is quite easy to see. It would vary according to individual cases. And certainly the facts of different cases differ. And of course, those may not be the same as the offenses we are discussing. But at least I think the judges should have a guideline. Let me go back and seek an understanding, and we can give you a written reply. Mr. Toh, well, I can also ask a related question. You can say, for example, do this. Whenever it is 7 years, usually then it's to a fine. But if it's 5 years, it may be $1 million. You understand what I mean?
So you think that any prison sentence over 7 years would correspond to unlimited fine. So, yeah, but if you found cases where it's $3 million corresponding to 14 years jail sentence. Now, and I would take that into account. Now, I think regarding drugs, there is a specified amount, and the jail sentence is says about 7 or 10 years. Understood. Next, page 11. Now this is relatively simple, Ms. Lee. Marked-up copy, page 11. This is section 9, clause 9 of the Blue Bill. We include 8 or 8A to be included in section 15 to specify the exceptions. Now it says such exceptions which may be specified. Now, is there a catch-all provision? Such exception may relate to any expenses, but are not limited to 1, 2, 3. So you're referring to 15B, right? Yes. (15) 1B. Now, as the Deputy Secretary said, now this is a list of exceptions, but which are not limited to the reasonable living expenses, etc. Have you omitted any expenses, or should it be such exceptions may relate to any expenses but are not limited to 1, 2, and 3? Would it be the DOJ who would answer this? Ms. Lee? Looking at the wording in English, Mr. To's explanation is correct. This is not just Roman numeral 1, 2, and 3. Now, I must admit that the English wording is rather old-fashioned and more difficult to understand. Such exceptions may relate to Roman numerals 1, 2, or 3, but are not limited to 1, 2, or 3. Now, Roman numerals 1, 2, and 3 are expenses or payments. So, if one applies, the authorities may agree with expenses other than 1, 2, and 3. So this is just a drafting issue. Now you added 8 or 8A. Now would you take this opportunity to see whether one should add so that such expenses may relate to any expenses but are not limited to 1, 2, and 3. We think the existing wording is quite clear. Okay, I will think about it. I want to cover page 13 as well. Let's go to page 12 first. That's clause 10 of the Blue Bill to amend Section 17 of the ordinance, that is applications to court of first instance. Likewise, this is to add 8A to Section 17 so that those affected by 8A can make use of the amended 17A to apply to the court for special permission or license. This is very simple also. Any question? Page 14 of marked up copy. Also to add 808A, Ms. Lee. This is also under Section 17 to add 8A. Because we deleted 8, so we added 808A. Page 15. Maybe I should ask the administration and the legal advisor to confirm once. Now you added 8A in all these cases. Now I didn't check one by one the relevant relief application or license. Is everything included? Now if there are places where you didn't add 8A, then you should explain why. Now after the meeting, we'll ask the legal advisor to cross-check with the administration. We still have a few minutes. Let's deal also with 14 and 15 because they are just about adding 8 or 8A. Okay, page 14 already covered. 15, marked up copy, page 15 is clause 11 of the Blue Bill. We propose to amend the rules of High Court, the 24(1) applications concerning direction mentioned in section 610 or license mentioned in section 6.1. Now, we'll end here because the next meeting will start at 4:30. We thank all those who are here. We wish you Merry Christmas. Sorry, one more thing. The next meeting is likely to be 8th of January. Now, I'd like to ask the administration, do you have sufficient time to prepare the information that members ask for? If you have enough time, we will meet at 2:30 on 8th of January. We will try to prepare the information ahead of time. So next meeting, 8th of January. Meeting adjourned. Thank you.